the resources are still not there. And so I guess on both standing, and to pick up on Justice Kagan's questions, standing and merits, and the Chief Justice's questions as well, there's a tradition of not allowing people to challenge non-enforcement decisions. Linda R.S. stands as probably the lead precedent on that. And so too, on the merits question, there is a tradition of reading statutes against the backdrop of prosecutorial discretion that, at least in the federal context, is rooted in Article 2, and then Castle Rock talks about that background principle in the state context. Those two things together are both probably united by the fact that there are never enough resources, or almost never enough resources, to detain every person who should be detained, arrest every person who should be arrested, prosecute every person who's violated the law. And so those two principles seem to me to come from the same problem. And that problem, even after the 2-year period you described, is present today, right?
Taking as an assumption that it would not be possible, we think that's at least disputable, but it's not possible to detain everyone covered by this. A couple of points. First of all, the prosecutorial discretion, typically prosecutorial discretion means the power to bring a criminal action and then pursue it or not pursue it against someone, or in this context, a notice to appear and to bring that all the way through to a final order of removal and execute or not execute it. Prosecutorial discretion doesn't prevent, as you pointed out, for example, in Heckler versus Cheney, Congress setting enforcement priorities, and it's not an excuse for an executive not to comply with a mandate on the executive itself. Now, I take the exception, of course, for a possibility that Congress said, you must prosecute this individual. I think that would be the sort of very core of an argument.
How about if Congress said you must prosecute, that the executive must prosecute everyone who violates this law?
I think that would be the strongest possible Article 2 argument available. Nothing in the text, nothing in the state's theory.
That'd be a problem under Article 2, don't you think?
I think so. Yes, Your Honor. I think that would be the strongest possible.
Well, how is that different from what we have here in terms of, you know, let's change that hypothetical. You must arrest, the executive must arrest everyone who there's probable cause to believe violated the law. How's that different from, theoretically, from this this provision?
Certainly, because two reasons. One, because essentially prosecutorial discretion doesn't cover every potential possible act of enforcement from soup to nuts in the process. It is the core of prosecutorial discretion is the ability to choose whether or not to bring charges and prosecute them. Now, I agree that perhaps that Article 2 question gains strength or loses it depending on how intrusive the invasion is. But here, 1226C1, as read alongside 1226A, and 1231A1, both respect the executive's prosecutorial discretion immensely. 1226C1 only applies until they have made a decision whether or not to prosecute. If they decide not to, it immediately ends.
Counsel,
Right,
I'm sorry.
I was the last question to tie this up, I'm sorry, is if you prevail here, what will happen? And that's a concern, because I'm not sure much will change because they don't have the resources to change. So what do you envision? I know Florida's amicus brief says, well, the executive will then strive to meet its obligations. Strive to is not a usual term of a judicial order. So what do you think happens if you prevail here?
We think, consistent with the district court's findings, that individual officers and ICE will go back to not believing that their enforcement discretion has been restrained in the ways the prosecutorial, rather the guidelines, the memos have caused that to be. More specifically about the lack of resources, though, Your Honor, there is an on-the-record finding of bad faith in this specific context for two reasons. One, here petitioners have repeatedly sought to decrease their enforcement capabilities, to decrease their detention capabilities, and two, they've persistently underused them.
Okay. Why don't you go to Justice Sotomayor?